Welcome to today's webinar brought to you by the Online Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com, a service of WFC & Associates. WFC & Associates is a national consulting firm that specializes in drug testing policy development and providing accurate and up-to-date drug testing law information. The Online Ultimate Guide to State Drug Testing Laws is the most comprehensive and up-to-date state-by-state drug guide to drug testing laws on the web. An annual subscription gives you easy-to-use online and password-protected access to the individual state drug testing law information that you need when you need it. Today's sponsor is Alere Toxicology. Alere is a leading provider of drug and alcohol testing services to the workplace, criminal justice, consumer, and clinical market. Alere offers state-of-the-art laboratory services at a number of locations across the country, including 2 SAMHSA-certified facilities. Alere is also a leading provider of point-of-collection testing products for urine and oral fluid specimens, as well as breath and saliva for alcohol screening. Today's presentation is entitled A Review of 2013's New State Drug Testing Laws and What You Should Know, and will be presented by Bill Current. Bill Current is the president and founder of WFC & Associates. Bill works with many of today's leading providers of drug testing and background screening services. He also works directly with small businesses and large corporations to help them improve their return on investment in drug testing. He is the editor of the Online Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com and the publisher of the e-newsletter State Drug Testing Laws Monthly and the weekly e-news service Drug Testing in the News. He is the author or co-author of 10 books on substance abuse issues, including Why Drug Testing. It will now be our pleasure to hear from Bill Current.
Well, Jessica, thank you very much, and welcome to everybody on today's webinar. This is our first webinar of the 2014 calendar year. Last year, we did over 40 webinars, hosting and presenting at some. Some of them were private webinars for clients of ours for their clients, but many of them were open to the public, like today's webinar. I want to especially thank Alere Toxicology for sponsoring today's webinar, making it possible to present this type of information to people in the drug testing and employee screening industries, as well as to your customers and clients. So thank you to Alere for doing that, and we'll be announcing at the end of today's webinar a webinar presentation that will be sponsored by Alere in February. So we look forward to that. We're going to talk today about state drug testing bills, legislation, introduced in 2013 and or passed in 2013. And that's why we're calling it 2013's New Drug Testing Laws. Most of them go into effect this year, 2014, but some of them are yet to be determined in terms of implementation and enactment dates, especially the marijuana laws. And as you probably know, if you live in a state with a medical marijuana law, for example, as opposed to the recreational marijuana laws that exist in Colorado and Washington, that once the bill gets passed, then there's all kinds of things that have to be determined, including where the dispensaries will be located and how they'll be regulated, and whether or not how they'll be taxed and things of that nature. So usually when a medical marijuana law gets passed or enacted, it may be another year or two before people can actually purchase marijuana for medicinal purposes. So some of those laws will maybe go into effect this year, but may not actually be in practical use this year. So what we're going to do is we're going to look at those states that passed legislation, created new laws in 2013. Then we'll talk about one of the 2 main parts of my presentation today, industry-specific drug testing bills. Then we'll get into synthetic drugs, workers' comp and unemployment comp issues, drug schedules, DUI laws, especially related to drug testing in particular. And then the second major part of today's presentation, the medical marijuana laws issue. We'll look at the current status of state legislative sessions, and then I'll share some of my 2014 predictions with you. I've been doing this for a long time. Started out with the U.S. Chamber of Commerce in 1989 and have been tracking state laws and state legislation related to drug testing in the workplace in particular, but for the last 10 to 15 years in the criminal justice market, treatment, etc. So this is something that we do through statedrugtestinglaws.com. It's part of the subscription service. If you're a subscriber, you know you have access online to legislative updates throughout the year. We send those out quarterly, but you can always go onto our website, log in with your subscription information, and find the latest information on drug testing related legislation. Some of it doesn't appear to be specific to perhaps a drug-free workplace, but it affects drug testing. So if you're in the drug testing business, which I know many of the people on today's webinar are, you'd be interested in, say, DUI laws relative to drug testing, or perhaps welfare drug testing laws, or unemployment drug testing laws. We'll talk about some of those today. So let's start out with just a review of the states that passed laws in 2013. Again, with the caveat that not all of them have gone into effect yet. But here's the list of 33 states that passed at least one bill or piece of legislation related to drug testing or that could affect drug testing or drug-free workplace programs. And you can see from this list that some states passed more than one. Arizona and Colorado, for example, each passed 4, but most of them passed, more than one. And this is a pretty big list if you consider the fact that, by my last count, there are 50 states in the United States. 33 of them passed laws in 2013 that could affect how you as an employer conduct drug testing in your workplace, or you as a drug testing provider conduct your business of providing your services to your clients and your customers. Now, to break it down, 7 of those states passed industry-specific drug testing laws, some that affect taxi drivers, for example, or healthcare workers, highway construction workers, etc. 7 states passed laws that affect drug testing by defining or broadening the definition of dangerous drugs. And this is a big issue in our industry today because it's very uncommon outside of the DOT regulations, for example, to find a non-mandated drug testing program. In other words, a drug testing program that is not in effect because the employer must do it to comply with a mandate or a regulation from the federal government or from a state government, and still be doing the 5-panel test from SAMHSA, marijuana, cocaine, opiates, amphetamines, and PCP. Nowadays, it's very common to find expanded panels that include perhaps expanded panels for opiates, or certainly benzodiazepines and barbiturates, etc. Some state laws are very specific. Some state drug testing laws, I should say, are very specific when it comes to defining which drugs you can test if you're an employer. And sometimes it'll refer back to a list that's found in some other regulatory agency within that state, and those will be the drugs that you can test for. Well, 7 states passed laws last year that either define or broaden the definition of a dangerous drug, and that can have a direct impact on how we do business. 6 states passed laws that add additional synthetic substances. We always think of K2 and spice, etc., but there are others related to that, to the list of banned drugs in those states. 6 states passed laws that add roadside drug testing to existing roadside alcohol testing laws, or have changed the parameters of a roadside drug testing law. 4 states passed laws that affect either workers' comp or unemployment comp laws relative to drug and alcohol testing. That, again, is a very big issue in our industry, and one that we probably don't pay as close attention to as we should. Yes, a state may have a drug testing law that is very specific, but it may also have a workers' comp law that has actual drug testing requirements in it that could differ significantly from that state's drug testing law. And so it behooves us as employers or as drug testing providers to know the workers' comp laws in our states and how they affect drug testing. 4 states passed laws that either affect workers' comp or unemployment comp laws that already existed relative to drug and alcohol testing. So we're going to talk about those. And then 10 states passed laws related to medical marijuana, with 2 states, Illinois and New Hampshire, passing new medical marijuana laws. And I point that out because there are 8 other states besides Illinois and New Hampshire that passed bills that are related to medical marijuana in those states. So obviously they were states that already had medical marijuana laws in place, or perhaps laws in place that allow for medical marijuana research. But in addition to those 8, 2 states, Illinois and New Hampshire, join the ranks of the states that have medical marijuana laws. And there are 20 states plus the District of Columbia now, as of the addition of Illinois and New Hampshire. And so that'll be the second major part of today's presentation. We'll get into that. But first, let's talk about industry-specific drug testing bills from 2013. Here, I'm going to go through a few examples. You know, there were too many, of course, to go through all of them in great detail, but let's just pull out some that are very interesting. In Arizona, for example, a bill was passed that requires employers to show proof of both pre-employment and random testing, in addition to criminal background checks of drivers in livery vehicles, taxis, and limousines. So that's a big deal, right? Because that creates, by mandate of a law in the state of Arizona, sort of a new cottage industry for drug testing of these types of workers. Now, the law requires the background check and the pre-employment drug test to take place before the individual starts working, whether the individual is going to be an employee or a leasee, and that random testing must be conducted annually. So sometimes, for example, in fact all the time, when we're writing drug testing policies, which is our core business, and we start talking about random drug testing, one of the things that many employers really don't understand is what a frequency rate is. You know, how many random drug tests are you going to do in a year, and at what intervals? And so we take them through the process of understanding what that is. Well, in Arizona, of employees in, say, the taxi industry, they must be randomly tested annually. And I couldn't find anything in the bill that limited it to just one random drug test. Perhaps there's something there I didn't see, but it does specifically require random testing to take place annually. So that's important. If you're in Arizona, you do business in Arizona, you have clients in Arizona, this is something you need to know about. In Rhode Island, there was a bill that was passed that amended an existing state drug testing law. Rhode Island has a fairly restrictive drug testing laws. And if you're in the business, you know that there are really sort of 3 types of states when it comes to drug testing laws. There are those that have mandatory drug testing laws, those that have voluntary drug testing laws, and then there are states without drug testing laws, but that are sort of governed by case law. Well, Rhode Island is an example of a state with a mandatory drug testing law. If you're an employer in the state of Rhode Island, you want to do drug testing, you must comply with the state law of Rhode Island. Now, just to make sure I haven't confused anybody, if you're in a state with a voluntary law, like I am here in Florida, where it's a beautiful 70 degrees today, and I know it's Hate Florida Day in some parts of the country, it's voluntary. You don't have to participate in the Florida Drug-Free Workplace program. But if you do, you may qualify for a 5% discount in your workers' compensation premiums, and that's a great incentive for many employers. But it's voluntary. In Rhode Island, what I'm saying is it's not voluntary, it's mandatory. They're not offering you a 5% workers' comp discount either. You must comply with the law of Rhode Island, and it's fairly restrictive. Well, they've loosened it up just a little bit. So here's what the language says. It clarifies that prohibitions that exist in the law do not, quote, prohibit an employer in the highway maintenance industry, and then it goes through a definition of what that is, construction, upkeep, maintenance, repair of states' highways, roads, bridges, et cetera, from requiring testing otherwise barred by this chapter, by the existing state drug testing law. Provided, however, that the testing being performed is performed as regulated under 49 CFR Part 40. That's another thing that you'll find throughout the country when you look at state drug testing laws is some of them have taken the time to very meticulously articulate the drug testing process, the procedures of drug testing, whereas in some states they simply punt on the issue and defer to 49 CFR Part 40, the federal guidelines. And so in Rhode Island, if you're in the highway maintenance industry in any of these categories listed here, you can do drug testing that might otherwise be barred by the Rhode Island law, but you have to do it in compliance with 49 CFR Part 40. Okay, so what's that mean? Well, in Rhode Island, for reasonable suspicion testing, the law was amended, and this is important, to broaden the criteria for a reasonable suspicion test. It used to say that you had to suspect that the individual was impaired. Now it's gone from the drug use is impairing to may be impairing. It loosens it up just a little bit so that other definitions that a company may use to justify a reasonable suspicion test now can apply in that particular industry. But you do have to comply with 49 CFR Part 40. So there may be some things in 49 CFR Part 40 that, would be contrary to perhaps the way a company was doing drug testing in the past. And that could be lots of different things. But you're going to have to use a SAMHSA certified laboratory. You're going to have to follow the 49 CFR Part 40 collection procedural guidelines. You're going to do your test in a lab as opposed to using a POCT device, etc. Okay? But it is good news in a way, at least in that industry, so that they broaden the definition or the criteria really for justifying a reasonable suspicion drug test. Now, in the District of Columbia, and this may not apply to many of you on the phone or on today's webinar, but it is important, okay? And let me read it because it gets a little complicated. When the office, and when they say office in this bill, they're referring to the Office of Healthcare Quality and the Department of Health and Mental Hygiene. So when the office conducts an inspection, the office shall verify that the nursing healthcare staff agency has developed, documented, and implemented procedures for, and then there's a whole list of them, right? But number 7, verifying prior to initial referral of a healthcare practitioner, this nursing personnel, to a client facility by the healthcare staff agency. So this is a healthcare staffing agency law. Drug screening of the nursing personnel referred by the healthcare staff agency if the client facility requires drug screening of its facility employees. So that's important. If you're in the healthcare staffing business in the District of Columbia and you're referring clients, healthcare or nursing personnel, for example, into a facility that requires drug testing of its employees, then that staffing agency must verify prior to the initial referral that that individual is subject to drug testing. Number 8, verifying when there is probable cause to perform a drug test or when a client facility requests a drug test. Drug testing of that nursing personnel, that healthcare practitioner, referred by the healthcare staff agency. Well, again, this is important if you're in DC and you're in the healthcare business of staffing or referring healthcare professionals into various facilities throughout the district, that you've got a drug testing program in place and that you can verify that your program meets the criteria of the law. So may not apply to everybody, but very important if you're in that business in that particular part of the country. New Hampshire, a little bit different. New Hampshire was in the news last year, of course, because they passed a medical marijuana law. And they're in the news again this year, if you noticed, because the state legislature just voted to legalize marijuana in the state of New Hampshire. Now, it's not there yet. The governor opposes it. But it's really the first time in our country that a state legislative body has collectively voted to legalize marijuana. In Colorado and Washington, of course, they were legalized by vote of the voting public. In New Hampshire, this is a big move. This is the legislative body, the elected officials of the state, voting internally within their legislative chambers or bodies to legalize marijuana. So in the news for medical marijuana last year in 2013, making headlines again this year, but they also passed a drug testing law, requires random drug testing 4 times a year. So that's significant, quarterly, right? Or at least 4 times a year, if not calendar quarterly, of all healthcare workers employed by a facility licensed by the state. The facilities are actually required to report workers who fail a random drug test. And the facilities that fail to perform these required tests can actually have their licenses suspended. And so, mandated? Absolutely. Penalties for not complying? Of course, license suspension. And, of all things, random drug testing required at least 4 times a year. That's a big deal. Remember, Arizona for the taxi drivers was at least annually, or annually is what it said. So this is a big development in New Hampshire. Now, North Carolina is an interesting situation. They passed a bill that requires pre-employment testing for what they call, quote-unquote, controlled substances of applicants for employment in adult care homes and in nursing homes. Again, activity in that area of employment. Now, POCT devices are specifically in this legislation permitted and they may be used, these devices may be used on site for pre-employment screens. Now, you may be familiar with North Carolina, so you'll know that in North Carolina, instant test devices, whether you call them on-site testing devices or point-of-collection testing devices, PSCT devices, etc., but instant testing devices are permitted for pre-employment testing only in the state of North Carolina. So this bill, which is specific to the adult home care industry and in nursing homes, takes that language, applies it in its situation, and clarifies that PSCT devices are permitted, and they may be used on-site at the facility, but only for pre-employment screens. Very, very important distinction. Persons who test positive may not be hired. I'm not talking about they may not be hired. They cannot be hired. By the law, they cannot be hired if they test positive. Unless, and this is a caveat unique to this bill, they can prove that they have a valid prescription for the substance that they tested positive for. And you have to go into the bill to read the specific language because there's some other requirements that go along with it. But that's sort of the bottom line of it. Now, the adult care facilities, it says, may require random and reasonable suspicion testing as a condition of continued employment. So in addition to requiring pre-employment, it specifically permits random and reasonable suspicion testing. There is some legal protection, limited liability protection, to facilities that attempt to comply with the law in good faith, even if they happen to employ a substance abuser. We all know that the average rate, positivity rate for pre-employment drug testing is about 4%, somewhere between 4 and 5%, depends on the industry. It could be a little higher, some industries quite a bit lower, but let's say it's 4%. But the average positivity rate for random testing is about 4 or 5% also if you go by national statistics. That means, of course, that in a place where you're doing pre-employment testing, you're still having people, get by that pre-employment screen and come into the workforce and join your payroll as substance abusers. And so if you're complying with this law in good faith, then there is some limited liability protection for that employer, even if they end up employing a substance abuser. And that's something you don't see in very many states. Utah has a provision in its state law like that. I believe Arizona does as well. But it's also important to note here in North Carolina, as this bill was passed, that all testing must be conducted in compliance with the state drug testing law, which is Article 20 of Chapter 95 of the General Statutes. That's the information you can find on our website as a subscriber. Just a little shameless plug there. Now, that completes the industry-specific drug testing part of today's presentation. You may have some questions. We encourage you to submit them through the Q&A section. If we don't get to all of today's questions, please submit them anyway by email. We take them and we respond to them if we don't get to them. So you'll get an answer to your question as long as it's related to the topic that we're discussing today. When it comes to synthetic drugs, not a lot to say here. As you know, there are about 44 states that have banned various forms of synthetic drugs like K2 and spice, the synthetic cannabinoids, bath salts, the substituted cathinones, other substances. Of course, the great challenge here is that each sort of blend of K2 or spice is made up of a very specific chemical compound. And so some states have made the mistake, really trying to do the right thing, but they banned the chemical compounds. And so the makers of these synthetic drug products just make slight changes to the chemical compound, the chemical makeup, and then suddenly they're back on the market with a quote-unquote legal synthetic drug. Some states have taken it a little step further, and they've actually banned synthetic drugs, period. And they've used the broadest possible definition of what a synthetic drug is. Now, you can see here with Kentucky and Rhode Island, for example, that they've actually amended or added to their state schedules of controlled substances to include some of these banned synthetic substances. And there are federal laws as well, as you well know. Again, the federal laws have made the same mistake where they're banning chemical compounds as opposed to banning the broad category of synthetic cannabinoids. And so it's constantly, a matter of, a dog chasing its tail. But nonetheless, you have to commend these states and their legislatures for making the effort and making it, a little bit harder for the synthetic drug manufacturers to do their business. Now let's move on to workers' comp and unemployment comp. And as I said at the beginning, this is an important category, because if you joined the call late, I'll just, in a nutshell, remind you that while a state may have a drug testing law, it may also have a workers' comp law that has specific drug testing requirements in it. So you may be in a state, for example, with a drug testing law that doesn't require, or say, for example, allows the use of alternative specimens or POCT devices, or doesn't say anything about using an MRO or a certified laboratory. But then when you get into the workers' comp law, in order to successfully move to deny a workers' comp claim, it will require that the drug test result come from a process that included, say, a GCMS confirmation result, a verified result from a licensed or a certified MRO, or that certain collection procedures were followed, et cetera, et cetera. So it's important to understand these workers' comp laws. And there were a few that were passed in 2013, some additions or amendments to existing workers' comp law. For example, in Kansas, added regulations for drug and alcohol testing for unemployment comp. And again, that's another area equal to workers' comp laws. Kansas, let me come back to in a second. Michigan amended its unemployment comp law to make failure or refusal of pre-employment drug testing a sign of rejecting suitable work. So as the unemployment rate continues to sort of hover at, wherever it's at, between 7 and 8% or 32%, depending on whose number you want to believe, if you fail a pre-employment drug test, that could actually hurt you in your effort to continue to qualify for unemployment benefits. And so the Michigan law was actually amended for that purpose, to meet that objective, which is interesting because when it comes to the drug issue, Michigan's a fairly liberal state. It has a medical marijuana law, and it's one of the states looking to legalize marijuana generally. Oklahoma modified its Employment Security Act. There's a ton of information in that, so I didn't put, I just named it here. If you want to look at it or if you have questions about it, let us know. But it's the Employment Security Act that was modified, and it touches on unemployment compensation and drug testing. And then Texas, new recipients of unemployment benefits, that is, must pass a drug test in order to qualify for benefits. And that drug testing must comply with 49 CFR Part 40 or an equivalent procedural standard is how it's worded. There are other requirements that go along with it, but it's interesting, isn't it? Because we've seen some states pass laws that attempt to require welfare recipients to be drug tested. And there's been a lot of pushback through the legal system against those types of bills and those types of laws. Now what's happening, and we saw this a couple of years ago for the first time and then starting to pop up more and more, are bills that would require unemployment comp recipients from receiving their benefits until they can pass a drug test or pass a drug test on a regular basis. So it's not for welfare, but it's for unemployment compensation. Well, that's potentially in some states a massive undertaking and quite an expensive undertaking. Who's going to pay for that? Because if you're unemployed, you probably don't have the money to be able to afford a drug test. So the money's going to have to come through a state-funded entity, and that money's going to have to come from some source. Taxpayers, perhaps. The federal government, perhaps. Except there's pushback on that type of drug testing as well. Discriminatory against people who don't have jobs. So I think we're going to see more of that. I'll talk about that a little bit more in my my predictions for 2014. But if I go back up to Kansas, you see that Kansas is a little bit of a throwback on that welfare bill that was passed. Here in Florida, for example, a bill was passed under Governor Rick Scott that would require welfare recipients to be drug tested. It was passed, of course, but then legal challenges sort of stopped it dead in its tracks before it could actually be implemented. And I think, like the one we saw in Kansas last year, certainly the one from Florida and several other states, we're going to see fewer and fewer of those types of bills, I think, and more that geared towards the unemployment drug test requirement in order to receive unemployment compensation benefits. These were just an example of some of the bills that were passed last year. Drug schedules, as I mentioned at the very top of the presentation, extremely important, but very, very complex. And some of these bills, you have to go in and you read them, like Oklahoma, for example. I went back to review that one this morning, just kind of, in preparation for today's webinar. Over 30 pages of lists of different drugs. And you would have to be in the business. You'd have to be, a lab technician or a lab director or somebody who really comes out of that part of the drug testing business to even pronounce most of those substances, let alone know what they are, what families they belong to, what categories of drugs they belong to, etc. But these are examples of 7 or 6, I got 1, 2, 3, 4, 5, 6 states that actually through the legislative process went back in and redefined what a dangerous drug is, as in the case in Arizona, or perhaps added in Louisiana certain compounds to the Schedule I classification of controlled dangerous substances. Very interesting, though, because again, if you're in the drug testing business or you conduct drug testing, you may be dealing with the state law that defers to these lists. And so when you ask if we can expand our panel of tests that we test for to include X, Y, and Z, it really becomes a matter of going back into these lists and making sure that the substances that you want to test for are included. Because if you're in a state where the drug testing law doesn't list, say, the SAMHSA-5, for example, but it refers to the state's Schedule I controlled substances list, then you have to go to that list to see if the substances you want to test for are included in the list and therefore legal in your state. Little provision that a lot of employers don't look at, and for many employers, not really an issue because you're going to find benzodiazepines and barbiturates under their various street names, but you may also, if you're, say, for example, in sports or you're in the healthcare industry, you're doing professional healthcare monitoring, and you're doing that type of drug testing, you may be dealing with all kinds of substances that the average employer would never even be concerned about, let alone know about. Well, you need to go back to these lists and check them. These are just states that amended their existing lists of controlled substances last year. Of course, every state has a list. And they're, you would think that we'd have one list, right, like the federal list, but many of these states have their own lists, and you've got to go back and be specific if you're in a state where the drug testing law defers to that list of controlled substances as issued by the state. I put an asterisk by Minnesota and Oklahoma because these are two states with state drug testing laws with extensive list of controlled substances, and they defer to the state lists. So something to be aware of. These are the types of bills that don't really get a lot of attention during the legislative season. They're usually passed without a whole lot of objection or resistance, and yet they could have an effect on how we do business, how we conduct drug testing, how we sell drug testing. Now, here's an area that's really growing in popularity. It's DUI laws, and we all know that there are DUI laws for alcohol testing, and you may assume that your state has a DUI law for drug testing, but perhaps it doesn't. This is a list of states that actually amended or passed drug testing, DUI drug testing laws, or amended existing alcohol testing laws for DUI, roadside testing, let's call them, to include drug testing. So for California, for example, it creates a DUI law requiring drug and alcohol testing, or I should say alcohol and drug testing. Kansas, Montana, got a couple of Montana bills were in there. One to amend the existing roadside testing law to include drug testing, and then another specific to THC. As you may know, when Colorado and Washington passed, or where voters voted in favor of legalizing marijuana in those two states, Washington already had a DUI cutoff level for THC, for marijuana. Well, Colorado didn't. And so in 2013, Colorado had to look at that issue. to establish, and those are still in process, but to establish a cutoff level for THC in DUI situations. North Dakota, Tennessee, Washington, West Virginia, Washington added marijuana to the boating DUI law. A lot of people may not think about that, but if you're in that business, that may be something that you've already taken note of, or you should take note of. Washington being, of course, one of the states that has legalized marijuana. Again, this may not apply to everybody on today's conference call, but it would apply to just about anybody who's in the drug testing industry, whether as a drug testing provider, a third-party administrator, or laboratory, etc. You may be dealing with customers and clients who are directly affected by this, or you may be in the business of providing these services within your state. And you're also, if you're in the business, you want to be aware of these because it could create new business opportunities for you in working with state agencies when it comes to drug testing for DUI. Now, let's spend a little bit of time with medical marijuana. And as I do that, let me just make the point that, yes, we've got legalized marijuana in Colorado and Washington, and there were a number of states, I think 12 altogether, that looked at marijuana legalization bills in 2013. My focus today is going to be on medical marijuana specifically, and the reason for that is we're seeing those laws get passed. 2 of them passed in 2013, bringing to total the number of states with medical marijuana laws to 20. Not seeing any new legalized marijuana laws passed in 2013. Of course, Colorado and Washington were actually passed in November of 2012, went into effect in 2013, and now in 2014, really, for most purposes, just getting up to speed. But we're going to talk specifically about medical marijuana laws. This is the list of states that have passed and enacted medical marijuana laws. I'm going to go through a little bit of the intent of these laws in a minute, but take a look at the state. You may be in one of these states. You may do business in one of these states or several of them. You may be an employer who does business in many states where you have operations in states that have medical marijuana laws. And I'm going to do a presentation on that in February, specifically on addressing medical marijuana in the workplace if you're an employer and you're in a state with a medical marijuana law. But these are the states that have medical marijuana laws. Now, I said I wasn't going to spend a lot of time on legalized marijuana bills and laws, even though there were bills introduced last year. But I want to point out the fact that if you're trying to predict where the next state that's going to vote to legalize marijuana like Colorado and Washington did, this is your list right here. Essentially, the pro-marijuana legalization people are working through the list of states where they've already started to break down the barriers against marijuana. So in a place like Alaska or California, Arizona in particular, Oregon, these are states that have already passed medical marijuana laws. It's legal to use marijuana in these states for medicinal purposes. Every state's different. There's no cookie-cutter legislation for medical marijuana. They're all different, but the bottom line is they legalize it for medicinal purposes. This is important to know because where the barriers have started to come down with medical marijuana laws, that's where you're going to see legislation introduced to legalize marijuana in general. And just last week, there was an article out that quoted the Marijuana Policy Project as saying they really feel strongly that they're going to be able to get law or bills passed in Alaska, Arizona, California, and Oregon in 2014. What they didn't count on was the legislature in New Hampshire taking that matters into their own hands and voting to legalize marijuana in New Hampshire. So the pro-marijuana people are predicting Alaska, Arizona, California, and Oregon, and New Hampshire is just a gift on top of it all. There are going to be others, though, but I'm just pausing on this list because if you're in one of these states, like, Alaska, Arizona, etc., this is where you can expect to see legislation introduced and start to make progress toward passing to legalize marijuana generally in your state, where you do business, where you live, etc. Okay? So this list is very, very important. This is the battleground for the legalization of marijuana in our country. Okay, these are other states that looked at medical marijuana bills in 2013. And you can see on this list some very conservative states, states where you wouldn't necessarily expect to see medical marijuana get legalized: Alabama, Florida, Iowa, Kansas, very conservative states. Now there's some liberal states in there like Maryland, Minnesota, New York. You may have seen that the governor of New York, Andrew Cuomo, made headlines at the beginning of the year, right, when he announced that he was going to legalize marijuana by executive order, sort of following the federal government's example of just sort of taking matters into your own hands as the executive. He's basically come out and said, by executive authority, I'm going to legalize medical marijuana in the state of New York. He's bypassing the voters, he's bypassing the legislative bodies, and he's saying he's going to just do it himself by executive order. Interesting approach, right? But on this list, yeah, there are some liberal states here, but there's some very conservative states, right? Two states that you absolutely would not expect to see medical marijuana laws: Florida and Texas, and yet they both looked at bills in 2013 to legalize marijuana for medicinal purposes, okay? This is in addition to New Hampshire and Illinois. Now, the intent of these laws, and I'm not going to spend a lot of time on this. This will be, sort of the core of the presentation, the webinar we'll do in February to bring you up to date on the marijuana issues. But the intent is to decriminalize the use of marijuana for people who are, suffering from really serious medical conditions. And so in California, for example, and this is sort of typical language that you see from state to state where they have medical marijuana laws, it removes state-level criminal penalties on the use, possession, and cultivation of marijuana by patients, and in this case, who possess a written or oral recommendation. In California, you don't have to have it in writing. You can just say that your doctor said, I need to smoke marijuana, right? And it goes on, and it has a litany of things there. But the conditions are very interesting. In California, it's a long list of legitimate medical conditions, like cancer, like multiple sclerosis, etc. But then it also it has this catchphrase: other chronic or persistent medical symptoms. And I always find that interesting to see something like that because, every Tuesday night when my wife reminds me to take out the trash, I get stressed out. And so wouldn't that be a medical symptom that would justify smoking a joint that night? Now, I don't smoke marijuana, and I wouldn't even consider it. But if you're in a state that doesn't even require a written recommendation, simply an oral recommendation, and you consider taking out or your wife reminding you to take out the trash every Tuesday night as a medical symptom, the stress that causes is a medical symptom, I bet you could find a doctor in the state of California that would agree with you and give you at least an oral recommendation to get some marijuana so that you can relax, and enjoy the rest of your night. I'm being a little facetious, but you do see some of these kind of loosey-goosey catchphrases, and you have to be, sort of looking for them. Here's Oregon, here's Alaska, here's Colorado, all sort of the same thing. Keeping in mind that because marijuana is still a Schedule I controlled substance under federal law, it's illegal for doctors to prescribe marijuana. They can only recommend it. And so you see the word recommend throughout these medical marijuana laws that have been passed and in the legislation that legislators are considering in various states. Not prescribe usually, but recommend. I did see the word prescribed in one of the bills that has already come out this year, and I wouldn't doubt that that'll get changed fairly soon. And then you see, again, like you see for Colorado, might benefit from the medical use of marijuana. There's no way to know how much marijuana it's going to take or what potency of marijuana you need to use or how often you need to use it. There's no way to really monitor it, right? Just might benefit from the use of marijuana for medicinal purposes. Okay, so New Hampshire and Illinois. Let's just talk for a minute about these two states because they passed bills in 2013. So they were both workplace friendly in most respects. In New Hampshire, it says, nothing in this chapter shall exempt any person from arrest or prosecution for, there's a litany of things, okay, but Section A is being under the influence of cannabis while, number 2, in his or her place of employment without the written permission of the employer. So in New Hampshire, you have to have your employer's written permission in order to be under the influence of cannabis while at work. And if you don't have the employer's written permission, then you may be out of luck. Now, on the one hand, you're probably not going to approach your employer to get written permission. But on the other hand, if your employer is your toking partner, well, then you may be able to get written permission very easily. But at least they went to that extent in New Hampshire to include that language. Also, as you can see in number 1, operating a motor vehicle, a commercial vehicle, a boat, etc. And number 3, operating heavy machinery, etc. So in New Hampshire, the legislators really did try to sort of give some cover and protection to the employer community. It also goes on to say nothing in this chapter shall be construed to require any accommodation of the therapeutic use of cannabis on the property or premises of any place of employment. So individuals who perhaps have a written recommendation to use marijuana can't assume that they can use it on their lunch break sitting in their car in their employer's parking lot, because the law covers that issue. Okay, very important. Now in Illinois, this is really actually pretty good news for employers. It's very employer friendly, the medical marijuana law in Illinois, and it's one of the very rare instances where you'll find drug testing actually mentioned in the medical marijuana law. Nothing in this act shall prohibit an employer from enforcing a policy concerning drug testing, zero tolerance, or a drug-free workplace, provided the policy is applied in a non-discriminatory manner. And certainly we can hope to do that, right, to apply the policy without discrimination. So in Illinois, the law does not prohibit an employer from drug testing for marijuana or for having a zero tolerance for individuals being at work while under the influence of marijuana, as long as the policy is meted out fairly. Okay, that's good news. There's a little bit more, though. Nothing in the act shall limit an employer from disciplining a registered qualifying patient from violating a workplace drug policy. So the law went into effect January 1st. I was just reading an update on it yesterday, and they're probably nowhere close to sort of really being out there with medical marijuana in Illinois. It's going to be a while still. But a registered worker who tests positive can be fired, and the employer would be protected. There would be some limited liability protection for the employer as long as he or she can show that their company policy is applied without discrimination toward anybody. Maybe a little bit of discrimination toward medical marijuana users, but only if they violate the company policy, which prohibits individuals from being at work under the influence of marijuana. And we're not talking about, and we're not using the word impaired, we're talking about being at work under the influence. You as the employer define what under the influence means. But one of those definitions should certainly be testing positive for marijuana. And then, in that instance, that individual has violated your company policy and could be subject to termination, and the employer would be somewhat protected. Now, I included just a little bit more information about Illinois. It's not pertinent necessarily to the workplace, but I think it's interesting to note that in Illinois, it's really, really sort of, it allows medical marijuana use. It certainly, meets the objectives of the pro-marijuana people, but there's some real caveats in here that are important to note. For example, patients cannot grow their own pot in marijuana. Patients and caregivers must be fingerprinted and undergo background checks and must promise not to sell or give their marijuana away. In Colorado, the legalized marijuana law actually includes, it's either Colorado or Washington, includes language that permits the gifting of marijuana. While in Illinois, if you pass that background check and you get fingerprinted and you're registered, you have to promise that you won't sell it or give it away. I don't know how much you can count on that promise being, complied with, but it's right there in the law. And it goes on and on. The only point of this slide is just to show that in Illinois, there were some protections built in both for the employer as well as for the individual, the community. So it's not a given that you can do whatever you want in Illinois when it comes to medical marijuana. In fact, there's some real restrictions and parameters established there. And of course, if you're in Colorado or you're in Washington, you already know the chaos that your legalized marijuana laws have created in terms of taxation, in terms of setting up legal marijuana dispensaries and stores throughout the state in places where they're not wanted, the prohibition on using marijuana out in public, and of course it happens, we're told, we read media reports that marijuana is used out in public and that the fine for doing so is so minimal that it's worth taking the chance, and that that law enforcement doesn't really enforce those laws. So you can see sort of the chaos that these laws create. And one of the things in our January issue of our newsletter, State Drug Testing Laws Monthly, we talk about the predictions from industry experts on 2014, and we spend a lot of time hearing their thoughts and predictions for the marijuana issue going forward. And one of them is that with increased availability and usage of marijuana, we can certainly expect to see an increase in accidents in the workplace and on the roads. And that will, of course, take a toll on the sort of public perception that marijuana is safe and harmless and should be sort of treated no more harshly than alcohol. Okay. This is just a fun little slide. These are some of the headlines I pulled off the internet last night just to show you medical marijuana, legalized marijuana, just all over the place. We're already tracking 2014 legislation. We've got, I think I saw about 12 or something pages already of lists of legislation that have been introduced in 2014 that affect drug testing, drug-free workplace, or are specific drug testing bills. These are some of the headlines relative to marijuana. If you go down several, about two-thirds of the way down, you see not a headline, but a link to a website, www.tokeofthetown.com. These are the types of websites that you can go to find update information on the legalization effort for marijuana in our country. Let me just remind you that there are many states that have already that are already in session at the state level. That's the first list there. And then other states that are just coming on. Alaska actually returned this week. New Mexico this week as well. And then there are states that are preparing to come back into session, and some states that are in recess. As you know, some state legislatures are two-year sessions, and so they may be in their midterm because they're halfway between their, they're a year into their session, and so they would consider it a midterm recess, like, say, in Oklahoma, for example. And then my 2014 predictions, and I realize we're sort of running out of time, but let me just go through them quickly. I think we're going to see more DUI drug testing bills, not alcohol, but drug testing bills, passed in 2014. Fewer straight welfare recipient drug testing bills like I talked about earlier. I think, we've seen legislatures and governors go down that path and get sort of pushed back by the legal system, but we will see probably more unemployment benefit drug testing bills like we saw last year. Just a few passed last year. We'll see more this year. Same number of medical marijuana bills introduced, probably somewhere between 12 and 15 to 20, with at least 2 passing. I think that's really conservative. I think we're going to see more than 2, but at least 2. More recreational marijuana bills introduced, and as many as 4 or 5 states, depending if you want to count New Hampshire in that mix, legalizing marijuana in their states. Pro-marijuana movement will look to close those loopholes. They have lost all the major medical marijuana drug testing court cases so far in Michigan, in Colorado, and in Arizona in particular, and you'll see legislation to amend existing medical marijuana laws to close those loopholes. And I think, again, we'll see national legislation in the U.S. House of Representatives to legalize medical marijuana and to legalize marijuana generally. We've seen that, I think, every legislature for the last X number of sessions. We'll see that again this year, but we probably will not see any of those passed. So we're sort of to the end of today's presentation, and I can see that we have a ton of questions. I apologize that I haven't left more time for questions, but I do guarantee that we will get to all of your questions. I did have a question in general about the Oregon drug testing law. Oregon, there's I think a misconception that drug testing is not permitted in Oregon. It is permitted in Oregon. There is a law for Oregon. You have to comply with that law. It's a mandatory law. It's not a voluntary law like here in Florida, but you are allowed to use, to conduct drug testing in Oregon. It's not specific to when testing takes place. So, for example, you can do pre-employment, you can do post-accident, reasonable suspicion, etc. But it does start to get into the procedures of drug testing, the use of on-site testing devices, which specimens can be used for testing. Those types of procedural issues are covered in the Oregon law. But I did want to clarify for the person who asked that question and submitted it ahead of time that drug testing is legal in Oregon. Now, you're probably going to see Oregon may be one of the states that legalizes marijuana in 2014. They came very close to legalizing it back in November of 2012, along with Washington and Colorado. It didn't happen, But as we head into, November, another election year in 2014, I think you may see that, you may see Oregon actually finally bite the bullet this year. But drug testing is permitted. And as I mentioned, Oregon already had a DUI cutoff level for THC before it legalized marijuana. Some of you are asking for lists. Just email me separately at bill@billcurran.com, and I will be happy to provide different lists for you. I did mention that it's 70 degrees right now here in sunny South Florida, and I just thought you'd all appreciate, one of our participants today has written that in Kansas it's -9. So I don't know what -9 means when it's 70 degrees outside and you're in short sleeves. Actually, I lived in Winnipeg, Manitoba for a couple of years, so I know what -40 means, but I'm glad to be in Florida where it's 70 degrees today. Have a question here. When a state law says in compliance with CFR Part 40, 49 CFR Part 40, does that mean a forensic chain of custody form with a DOT lookalike panel? Well, two things. Some laws, like the voluntary law in Ohio, which used to be very broad in terms of procedural requirements, now sort of defers to 49 CFR Part 40, and I'd have to go back and look to be sure. It may defer to the U.S. DOT regulations, which of course brings us back to 49 CFR Part 40. But usually they don't go into that much detail. Melissa submitted that question. So you would have to go back and assume that the intent of the legislature when they wrote that law was to not get bogged down with procedural issues that could be argued, ad nauseum, but to defer to these federal regulations that have passed the legal test of time, the scientific test of time, and require employers to use that process. Now, when it comes to a DOT lookalike panel, now I have seen some states that defer to the DOT regulations to 49 CFR Part 40, but will actually define what a panel can be, or they may allow lab-based oral fluid testing, which of course is not part of 49 CFR Part 40 at this time. And as you know, if you're in the industry, you know that a lot of buzz in the industry is the ongoing development of federal regulations for lab-based oral fluid testing. Not here yet, but when that happens, it will be part of Part 40. DOT has already signaled that they will adopt those regulations, and so states that have laws that simply defer to 49 CFR Part 40 or to the DOT regulations would by default, adopt lab-based oral fluid testing as well. Not necessarily. I mean, there are very few states that prohibit lab-based oral fluid testing now, but you find very few states that have regulations for lab-based oral fluid testing. When those SAMHSA regulations come out for lab-based oral fluid testing, a lot of states will probably at least refer to them, if not defer to them entirely. I did have a question here on providing a statute number for a drug testing law in the District of Columbia. Jim, I can do that for you. I don't have it right in front of me, but please email me and let me know you want that, and I'll get that for you. Is the North Carolina adult care law already approved, or will it start sometime in 2014? My understanding, as I reviewed that last night, is that it will start in 2014. But I can find the implementation date, the enactment date for you on that. And so, Susan, if you want to let me, just email me and let me know you'd like that, I'll get that information for you. Are there state-specific updates to laws for Florida? Florida has occasionally done a little bit with its state drug testing law, which is a voluntary law. I described it, the workers' comp premium discount law. But it's really been a while since anything significant has happened with that. There are some state contractors that are mandated to comply with the components of that law as if it were a mandatory drug testing law. It is for some state contractors. For the general employer public, it's not. It's a voluntary law. Not a lot of changes to it over the last 3 years, but there were some about 3-4 years ago that were fairly significant. So that's a question from Beth. Beth, if you'd like to know more about that, please contact me and I can provide that to you. Not anything I'm aware of specifically lately. Although, as you know, Florida was one of the first states to pass a welfare drug testing requirement. It was held up by the courts, but there was that effort to go forward with that. I can see we're out of time. Thank you very much for joining us today. We had a record turnout. If you'd like more information, please contact me at one of the numbers or the email address on the screen. And certainly, again, we'd like to thank Alere Toxicology for sponsoring today's webinar. Please reach out to them at the number and the link that's provided there on your screen if you have questions about the services that they provide. And with that, I will turn the microphone back over to Jessica.
Thank you, Bill. On behalf of the online ultimate guide to state drug testing laws at statedrugtestinglaws.com and Alere Toxicology, we hope you have found today's presentation informative and helpful. This presentation was recorded, and you will receive instructions informing you how to access the recording. Thank you for your attendance. This concludes today's webinar.